back. Our Nebla Beard and Arsenal Legal Difference segment continues today. This is Mike Koch, and we're going to talk a bit about the appeals process this morning, what that's all about. So good to see you again, Mike.
Good to see you, Mark.
Still riding high from the LSU-Bama game, huh? We were just talking about it a minute ago.
Definitely still riding high on that. Very exciting. I was lucky. Two of my boys came in, so
yeah, I got to watch it.
Yeah, watch it together. Yep. Doesn't happen too often, but to catch that special moment, it was really great.
You heard it here first. LSU and Clemson for the national championship in
I'm in
January.
for that. Okay, great. I'll second that.
All right. Meanwhile, the appeals process.
Okay. Let me tell you a little bit about it. Like in any court we have, and I'm going to start with like our city courts. We have the Alexandria City Court and Pineville City Court, and then we have the State District Court right down the street. All of those courts that if you go in there and you try, you have your case tried, whether you're the plaintiff, the one bringing the case, or the defendant, you have a right to appeal the verdict, whatever it may be. And then they appeal it to what's called the Third Circuit Court of Appeals. That's in Lake Charles. It's made up of 21 parishes, and there's approximately 12 appellate judges on there that are elected for 10-year terms. And we have one from Alexandria, Judge Shannon Grimion, who serves on the Court of Appeals.
Gotcha. Why would you file an appeal?
Yeah.
Why would you do that as an attorney?
That if you're dissatisfied with the verdict, obviously it costs money and time to appeal, so you don't want to just appeal anything for any reason, because one, you're wasting your time, and two, if you don't have a good faith basis, then they can sanction, the lawyer for doing it. So you don't want to do it for delay. You want to do it because you believe that the judge could have applied the wrong law to the scenario or case fact pattern, or that they were just clearly in error on the factual determination. So those are the two main reasons why you would file appeal. And you want to feel that you have a chance to win, because you don't want to just, just do it to do it. Well, a lot of times people
have a strong case.
Right, exactly.
How do you file an appeal?
What you would do is, the best thing I believe is a lawyer should file it, but every once in a while you have people can file it on their own. What they would do would be file a notice of appeal with the whatever court you're in, whether it's city court or it's a district court. And then the judge would sign the granting the notice of appeal, and then he would set a time for the record to come in. Because in all appeals, what happens is the court reporter's taking down all the information, typing it up. So when you go to the appeals, only thing what happens, you have 3 judges up there, and they just review the record. And that's just, there's no live witnesses, there's no exhibits coming in.
Right.
You don't get to testify again. You had your shot. They're going to read the cold transcript.
Right.
And that's what they do to make their decision.
Their decision.
Right.
How long does the appeals process take, Mike?
That's a good question. A lot of times it could be really quick. Like you could be in a trial and the judge can rule against you, and you can file for what's called a writ, appeal of that judge's decision, and you let them know you're in trial, and they can get it back maybe possibly the next day. But those are emergency type situations. Typically, though, it could be anywhere for 2 months to 6 months before you get a decision.
Right.
And that's just not from the time you got your decision in the lower court, because you still have to wait for the record to be transcribed, and then the court gives you time to file a brief, and it gives the other side a time to do a opposing brief on it.
Right. Are there different type of appeals that you can go with?
There are 2 different type of appeals. One is called suspensive appeal, and that's something that usually you have to put a bond down, because there's usually money involved. And what you're doing, you're asking the court to suspend execution of that judgment. So if somebody gave a money judgment against you, or the judge did award it against you, you can suspend it where they don't get to collect on it until you have a right to go get your case heard by the next court, which would be the Court of Appeals. Right. And then the other one's called devolutive, and that's a different time frame. It's 60 days instead of the 30 days. And that's something that doesn't suspend it, but you can get the judgment reversed based on that.
Interesting stuff. So if anybody had any questions, the best way to get in touch with you at Nebla Beard and Arsenal, Mike?
Yeah, just call Mike Koch at Nebla Beard and Arsenal. Happy to answer any questions they have.
There you go. Thanks for coming, Mike.
Thank you, Mark.
Good to see you.
You too, my friend.
We have more to come on this Thursday. The Grant Parish Sheriff's Office pancake and sausage breakfast. That's coming up.